morning, Judge Grayson. How are
Look
you?
at that smile. I mean, you must be ready to go then.
I've been looking forward to this.
All right, you got it.
I just have to get my paperwork.
Take your time.
You have paperwork.
Take your time.
Wake up with it. You check them?
You may proceed, Attorney Ward. Thank you.
I think before I call the first witness, I just wanted to address something preliminary.
You may, thank you.
This case involves a stalking protective order that was issued by this court. The court has the petition, has all the records. I'm going to ask that the court, as far as I know, Mr. Parisi isn't arguing the existence of that order. I don't believe that's an issue. The court has heard all of that regarding the order, so I was just going to ask that the court take judicial notice of the order, the existence of it. It was served. The court should have the return of service. The court should also have the form in which the order was ultimately withdrawn back in November. We just ask that they take judicial notice of the existence
Sure,
of
and that's common. Any objection, Mr. Parisi? So noted. Thank you, Attorney Ward. Proceed.
So, first witness, the state calls Officer Colin Germain.
I'll wait. Take that check with you, sir.
Could you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, other than the pains and penalties of perjury?
I do.
You can have a seat. Could you please state and spell your last name for the record?
My name is Colin Germain. My last name is Germain.
And are you currently employed?
Department.
And how long have you been working for the Keene Police Department?
I've been working for the Keene Police Department since 2019.
And how long have you been working in law enforcement?
I've been working in law enforcement now for 9.5 years, starting back at the county jail in 2012.
And you said you took the academy when?
The academy I entered in was the spring of 2017.
And you successfully completed that?
I did.
So I want to bring your attention to October 31st of 2021. Were you working for the city of Keene on that date?
I was.
In what capacity?
I was working as a uniformed police officer.
And do you recall which shift you were working at?
I was working day shift.
All right. And do you recall being asked to make a phone call or return a phone call that morning?
Yes, ma'am.
And who was that phone call?
It was John Connolly.
And why were you asked to call Mr. Connolly?
Mr. Connolly was calling to report a violation of a protection order.
Okay. And did you call him back? I'm sorry. At this point, were you at all familiar with Mr. Connolly?
Not particularly.
And did you know at that point in time who the protective order was against?
Yes, it was against Mr. Thomas Parisi.
Okay. And are you familiar, at that point, were you familiar with Mr. Parisi?
Not personally, but through other officers' encounters, we were...
And at that point, what did you know about Mr. Parisi?
I knew that Mr. Parisi had a number of protection orders out against him and that he operated a Facebook page known as the Jail Paper.
Okay. And have you ever viewed that page?
Not
in your
particularly.
capacity as an officer?
No.
Yeah. Did you know anything about what that page was at that time?
From speaking with other officers, it pertains to him exposing or following around convicted sex offenders or criminals in the city of Keene.
Mr. Connolly back right away?
No, ma'am.
Okay, what did you do with it?
I actually went on the Facebook page and watched a few videos. One in particular was aimed at Mr. Connolly.
Okay. And so is this Facebook page publicly accessible, or did you have to do something special to have access?
It was public. All I had to do was type in the jail paper.
You said that you had viewed some videos on the jail paper at that time before calling Mr. Connolly back. And you said that actually involved Mr. Connolly?
Yes, ma'am.
Okay, do you recall what the video was about?
The video that I watched, a male subject wearing a mask identified himself as Thomas Parisi, reported that he had an interaction with a state trooper and a supervisor from the Keene Police Department, and them addressing him stalking Mr. Connolly.
Do you recall when that video was posted?
I believe it was posted the few days prior, or the day before, the evening prior.
Your Honor, if I may,
You may.
I would like to approach, I have the video here on my computer, and I would like to play it for Officer Germain, and
Has Mr. Parisi already seen it?
he should have received it.
Seems like a silly question, but, you know?
He also posted it.
It seems like a silly question, but I don't know that yet. All right, thank you. You may approach. Thank you. Mr. Parisi, move where you need to move to see it. Thank you. I can see that good, Attorney Rourke, if
Okay,
that's
it's a
helpful. I don't know if the
little
witness can see it. but
Okay.
Large.
I can see it.
It's the jail paper. We survived. Higher quality, we're going to stop doing live videos. Because apparently today, someone watching the live video called the police and said that I was stalking John Connolly. One nice gentleman from the state troopers and one nice gentleman in car number 29 from Keene PD came to speak with me. And as you can see, no silver bracelets, and I'm not stalking. But listen, John Connolly, why don't you report to where you're supposed to report to? You're not supposed to be in a van down by the river. You're supposed to be in bed at 100 Nights, because that's where you're registered to, mister. I'll be watching you. Thomas Parisi for the jail paper.
And is that the video that you recall watching prior to calling Mr. Connolly?
Yes, ma'am.
So after you watched this video, did you call Mr. Connolly back?
I actually didn't get a chance to. He actually showed up in the lobby.
Okay, so you met with him in the lobby?
Yes, ma'am.
And can you please describe that interaction with him in the lobby?
Mr. Connolly was pretty upset. He had the videos on his phone. He attempted to have me watch them. As soon as I saw the video that he was going to show me, I explained to him that, hey, I had just watched this.
And what did he have to say about that video?
He presented me his copy of the protection order that he had against Mr. Parisi, and he identified the section which specifically states that Mr. Parisi is not to have contact with him either first person, third person, through mail, fax, and social media, et cetera, et cetera.
Okay. And you saw that in the protective order?
Yes, ma'am.
Were you able to confirm that at all?
Yes, ma'am.
So after speaking with Mr. Connolly and taking that report, what did you do?
Essentially what I did was I went and I spoke to my supervisor because I had an opinion on the matter to kind of confirm or deny what I believed at the time.
And what did you determine from that?
So based on that conversation, it kind of agreed with me that, hey, at the time, we did not believe that it was a violation of the protection order.
Obviously, at some point.
Yes, so a few days later, a different supervisor approached me and presented me with case law that greatly changed my opinion of the matter.
And did you speak with Mr. Parisi about these videos at all?
I did.
Okay, and can you just describe briefly that conversation?
The conversation in question was more, hey, you need to stop because what you're doing could eventually lead to criminal charges. At the time, it was still active.
And do you see Mr. Parisi in the room today?
Yes, ma'am.
And where do you see him?
He's right here.
And what is he wearing?
He's wearing a red tie and a gray suit jacket.
I just like the record to reflect that the witnesses identify the defendant as Mr. Thomas Parisi.
So noted, thank you.
All right, thank you. I don't have questions. No more further questions.
Mr. Parisi, any questions?
Yes, sir.
You may. Thank you.
I did want to ask the court, a matter of procedure, I don't have a copy with me of the narrative, but I presume as Attorney O'Rourke had asked if we can acknowledge the existence of the order, could we acknowledge the existence of the arrest affidavit and all that other, all those other documents with it? I don't have the actual physical copy with me, but it's something that the witness or Officer Germain had wrote himself. So I do have passages in here that I wanted to
You
ask
may.
questions.
Go ahead, thank you.
Officer Germain, how are you today?
I'm doing well.
Right. So I was, let's see, I have that. So, bear with me 1 second. So Officer Germain, had we had any prior interaction before, the first time that we had interacted on Halloween, I believe it was October 31st?
I can't remember, to be honest.
When was the first time had you reviewed this stalking petition? When were you first aware of John Conley Jr.'s stalking injunction that he had against me?
I honestly can't remember.
Oh, let me do this better. Okay, would it be safe to say that on, I believe it says on October 24th, according to paragraph 2 of your thing, is when the initial, sorry, I'm kind of out of sorts, Your Honor. I don't have the affidavit, so I have the witness's notes from it. Can I read that into the record?
You can't read into the record, but you can take your time, take a deep breath, take your time, look through what you got to look through.
Thank you, sir.
No trouble at all.
Bear with me one moment, Mr. Germain. Oh, there we go. So, in your affidavit and narrative, did you acknowledge that I was a journalist?
I did not.
Okay. And, well, in documenting encounters and circumstances, and then subsequently publishing these encounters and circumstances that you have described, that going after known sex offenders, would you consider what I was doing a form of journalism?
I don't really have an opinion on the matter.
Okay. Are you familiar at all with a case referred to as implode, explode, mortgage specialist versus implode, explode?
No.
No, okay. And how familiar are you with State versus Craig before you had initially seen it?
I was not familiar with it at all.
How much did you review State versus Craig?
I read it at length.
Can you tell the court in a very brief way how you interpret, to your own way, that you had come to your acknowledgement that you had seen what had gone from what you saw as not a violation to a violation? How did State versus Craig change your opinion?
So, State versus Craig was a case where a subject was involved in stalking behavior, sending mail to a woman and posting publicly on his Facebook page, which was not set to private, where he directed messages at a specific person who was the protected party in an order against him. Because the page was public, that she could then access those messages, it would then complete the violation of the protection order.
Okay, excellent. Your Honor, I have 2 copies of State versus Craig. I would like to see if I can enter them as evidence.
I think, the state doesn't necessarily object to that, but I think when it comes to the case law, I would reserve that for argument. You want to make some argument about, I plan to make an argument, I think, because I think really the crux of this case is whether or not that video falls within the confines of State versus Craig. Or he can.
I was looking, Your Honor, for one passage to see if Officer Germain had read specifically to the freedom, where there's certain constitutional activities such as freedom of expression, freedom of the press, that are specifically outlined within State and Craig that do not fall within the criteria of what this officer had charged me with. So I wanted to enter in State versus Craig if the if the
It's, I agree with the state that it's
argumentative.
a little, no, it's a little out of sync right now, but if it'll help your flow, I'll accept it right now.
Okay. Bear with me 1 second. 'Cause I
As
have-
defendants A,
Yes, yes.
Thank you.
Oh, okay. Let's see. And bear with me just.
no trouble.
It's very good. Your Honor, if I can have an example of part of Statement Craig, if the witness had read it, I would like to see if I can have him read one passage of State versus Craig of the examples of stalking behavior.
I'll give you some leeway on that,
I appreciate it.
no trouble.
And I will highlight the section, which is right here. And if you, Officer Germain, could read that small part starting with kitty cat, comma.
Are you referring to the
That
dear kitty
paragraph.
cat?
Yes, yes.
I should remind you that since you would have to choose to look at the things I say to you on Facebook, that it means my butt is covered. Also, you are not allowed to do anything back to me all week, as it would constitute a breach in your end of the whole restraining order thing. So technically, you are the one in cuffs. Ha ha.
So now, was this published, because you had mentioned this was public, was this published on an individual Facebook page, a business Facebook page? Where was this published on?
The video that was posted,
No, this.
it was
State versus Craig.
it was on a personal Facebook page.
Excellent, okay. Let's see. And were you aware of at the beginning of the investigation that John Conley Jr. was a known sex offender? When you were aware of John Conley being a sex offender when he initially made contact with you about this violation?
I didn't think it was relevant.
Okay. All right, good.
I'm sorry, I just didn't hear that.
I didn't think it was relevant.
Okay, I just didn't hear the answer.
It's not your name, I guess. Okay, so are you familiar with Facebook? More or less, do you use Facebook?
Yes.
Okay. And, let's see, and in setting up the account for Facebook, did you read the terms and conditions of Facebook's service and policies that users have to abide by?
No.
Okay. Let's see. So now what I want to do, Your Honor, is I have with me that I wanted to try to enter into evidence was this Facebook's terms of service and conditions of use, which has in it specifically that convicted sex offenders are not allowed to use that platform. In publishing this alleged said video, I was under the impression when I published it, individuals like John Conley Jr., who were not allowed to use Facebook to begin with, wouldn't be on that platform, which I'll introduce later, because obviously there's a video with me with a mask that's published in there. However, the terms and conditions of service for Facebook are not allowing individuals like that, and John Conley Jr., which I'll enter in when he comes in, John Conley Jr. is prohibited by his sentencing to be on it. But would I wait to enter the Facebook terms and conditions after when Conley comes in or now?
Well, you've got a couple questions there. The last one is that the flow is kind of up to your feel and how you want to present it. And I don't want to dictate that to you, but let me see if Attorney O'Rourke has any issue with the terms and conditions.
I have no issue with that, but I'm happy to stipulate to the fact that they have these terms and conditions that prohibit people who are allergic. I think that's what Mr.
Sure.
Parisi is trying to say.
Yeah.
I'm fine stipulating to that fact that that is accurate.
So there's no need, she's agreeing you're
I'm
right.
agreeing.
There's no need to prove it to me. She
Yeah,
said you're right.
Thank you.
Thank you.
And now, basically, if I had set up the jail paper on Facebook and I began reporting on known sex offenders, as you had stated, I must have agreed to it. So do you think that I could rely on Facebook's terms of service to only allow authorized users who have the right to be on Facebook, as I had mentioned, excluding persons such as known and convicted sex offenders. Would I reasonably, as a reasonable individual, have that expectation? Would you believe?
I suppose.
Okay. And I'm going to wrap it up now. If you want.
Take your time.
Is it possible, because I'm very lacking in procedure, I'm overexcited, but I appreciate the court's patience. Is it possible to call him back as a witness for a brief question after Mr. Conley?
Highly
Sure,
unlikely,
just-
but if you
okay.
can convince me there's a good legitimate reason to, you can, but highly unlikely.
I think this is all. I
Keep
think
your
I'm
number
back.
there?
Yeah.
All right. Attorney Work, anything to polish up?
I just want to ask one
Sure.
question. After you read or became aware of State v. Gregg, did you feel at that point that you had some probable cause to file or a reason to file an arrest warrant?
Yes, ma'am, I did.
And you got an arrest warrant?
Yes, ma'am.
No further questions.
Wing
You
for
may, I could tell the way you were looking.
Yeah, okay.
The famous one more question.
Yeah, excuse me, Sean, one more question. So, how many times have you actually, in a law enforcement capacity, you have been a law enforcement officer for 9 years now?
Going on.
If I'm correct from our conversations, you had worked initially at the jail,
Yes, sir.
and then you worked for Marlboro Police Department,
Yes, sir.
and then you came to Keene Police.
Yes, sir.
Now, through your 9-year career in law enforcement, how many times have you found State versus Craig applicable to you being then compelled as a police officer to serve the community and arrest, an individual in violation? How many
Well-
times have you felt compelled that you had to find State versus Craig to be able to stop somebody?
I can tell you that was the first time I've heard of State v. Craig. So it changed my opinion of the particular case that I dealt with.
Now, let me ask you, how far did you get in school?
I graduated college,
Okay, and your highest level in college is?
4 years. I have a bachelor's.
And what law school did you attend?
Plymouth State.
No, what law school?
I didn't go to law school.
Okay, no more questions.
Anything to polish?
Nothing further, Your Honor, no.
This gentleman be excused.
You may.
Thank you. Thank you, sir.
Yes, sir.
We would now like to call Mr. John Connolly.
You may, thank you.
Just remain standing and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
You can have a seat. Can you please state and spell your last name for the record?
My last name is Connolly, Connolly.
And Mr. Connolly, do you live in this area?
I do.
And are you currently employed or working?
I'm not.
How long have you been living in this general area?
Since I was released from jail, I believe it was July 28th last year.
And obviously you're subpoenaed to be here today as a witness in this trial involving Thomas Parisi. Do you know Mr. Parisi?
Not personally.
Do you know of him?
Yes, I do.
Do you know of him?
He is involved with the people that I'm like the homeless and stuff like that. The people that I hang around. He's into drugs and stuff like that, so he's always around. People are always talking about him and always telling me things like he's looking for me and stuff like that.
Now you said that he knows people that you are associated with.
Yes.
I heard that you applied to you're currently homeless.
Yes, I am.
And when you refer to these people, who are these people that you are?
Just individuals that I've met at the 100 Nights Shelter in the community. Unfortunately, we're like the cast sides of society, so we kind of congregate together at sometimes, and he's always bugging someone, so.
I do have to ask, when you refer to we, who are you? Who is we? Who are these people that are congregated together? You said something about being an outcast. I'm sorry, I'm having a really hard time hearing too, so.
You want me to name everyone?
No, but who are these people? You're saying, you seem to be clumping yourself in with a group of people.
The homeless.
Objection, the relevance to this line of questioning just eludes me as to what these fictitious people that we're mentioning here, I don't understand her line of questioning where this is going to.
I'm trying to lay the foundation to get
You
to
may
the next
proceed,
slide.
thank you. You may proceed, thank you.
Thank you. Okay, so you're hanging out, you're associated with the homeless population.
Yes.
And you've indicated that Mr. Parisi is somehow related to these people, or in a way has some sort of connection with these people?
Yes, he does.
And how is that, what is that connection? Have you had direct contact with him?
No, I haven't. I haven't had direct
What kind
contact.
of contact have you had with Mr. Parisi?
He just looks for me, I guess. He wants to videotape me. He keeps saying that I've been absconding, and I guess he's trying to get me, picked up by my operation officer. I've never absconded a single minute. The two people that I have to report to know my every move before I make it. And when Mr. Parisi first started documenting me, he created such a public spectacle that the homeless shelter said, listen, there's nothing against you personally, but they were gaining a lot of unwanted attention, so we're going to have to, not have contact anymore. So that I lost a big resource there. I lost where I was living. Thank God I had a vehicle that I could stay in. And after that, he couldn't find me because he got me kicked out of the only place I had to live. So he would be there all the time. Anytime I would go back to get food or something at the drop-in center, people would be like, he was just here, he's looking for you, he's posting all this stuff about you. He's stalking me. I don't know what else to say. I think he probably has some mental issues that he should work through. I understand why he's doing it, but how he's doing it is wrong. The things he's saying is slanderous because
So you
they're not
said
true.
that- I'm sorry to cut you off, but you said that people were telling you that he was posting things. Are you aware of what those things were?
Yeah, sometimes I would see things, snippets here and there. They were always very bad. Usually my picture and slanderous things that he would say. Some true things, he would get some things correct, but he would just go off on a tangent and say a lot of untrue stuff. When he first did this, I was using Messenger, which I was not aware that it was.
We're going to get there.
Sure.
I just want to slow you down for just a second.
Sure.
So you were made aware that he was posting some things. Where was he posting them?
On Facebook and YouTube And I think he posts stuff on TikTok and Twitter and pretty much everywhere. So,
All right. And so you have viewed some of these on various social media? You've actually seen these posted?
oh, the only ones I've seen is like on Facebook and YouTube.
Okay. And did you reach out to Mr. Parisi at all about these posts?
The original post that he did, he started reporting on 100 Nights shelter, and he was making a lot of claims, mostly about sex offenders that were staying there, and I knew it was just a matter of time before my name came up. Obviously, it's something that everyone's embarrassed about. So when my picture was finally posted as his main profile picture, that's when I contacted him through Messenger. Now, I was using Messenger just as a text message service, and it allows you to message Facebook users. So I messaged the jail paper Keen, and I said, listen, I understand what you're doing. I understand that, the community has a right to hear if there's any risks in the community, but what you're saying about me is wrong. I tried to explain to him what exactly that I was convicted of and the difference between the two that he was saying. I was not trying to start a confrontation. I was respectful and professional, and I asked him if he was going to say something, just please use the truth. And then he posted all of it on Facebook and said a lot of bad things and said, this person is illegally using Facebook and this and that and blah, blah, blah. He didn't want to have any type of conversation or anything. He was just using this as he is right now, making a spectacle of me. So I talked to my PO afterwards that day because he was like, I'm going to contact this probation officer. Contacted my probation officer at the time, which was Ryan Conover. And I said, I currently use Messenger. And he said, I was like, is that part of Facebook? Can I use that? He said, it is part of Facebook, so you can't. I deleted it right there in his office, and I've only used whatever the base text message service is now. And
Do you recall when you sent that message to to the jail paper, you said?
a long time ago. It was probably late summer of last year.
Okay. Your Honor, if I may approach.
You may, thank you.
Copies of those messages that Mr. Connolly is referring to. This is your.
Thank you, Carmen. I appreciate it.
Mr. Connolly, do you recognize these?
Yes.
Okay. And what are those?
That's the initial message that I sent him, asking him to recheck his information, basically saying that what he was saying or portraying me to as a public was slander because I didn't do the things he said.
Okay.
I told him what I did, and I posted exactly the statutes and everything that I was convicted of, and yeah.
And these are really hard to read. I had a hard time printing these out, but can you see on there where it indicates the date of when these messages were going back and forth?
I believe 9/24/21.
Okay. And does it indicate who responded to those messages on there?
Sent by Thomas Parisi, so it was myself and Thomas Parisi.
Okay, all right, thank you. Your Honor, I'd like to enter this in States 1.
Any objection?
No, Your Honor.
Thank you. So noted, states one. Thank you.
you sent those messages to the jail paper, which was responded to by Mr. Parisi, did you have occasion to be made aware of any other postings that were continuing after you had sent that message?
Yes, it was nonstop.
So what, if anything, did you do at that point?
I asked my probation officer what type of legal things I could do. Unfortunately, he said, there wasn't much. He said that I could try to get a restraining order. Of course, a lot of the people that were going through the same kind of thing that I was living around or was living around. But for some reason, he was just focusing on me. It was probably because I tried to defend myself. And so I found out that I could get a restraining order. I called the police. I said, this man is looking for me. He's actively looking for me. Everyone I know is telling me where he was last night. He comes out at like 3 in the morning with a mask on, and he tries to find me. He said that he's going to videotape me sleeping in my van. He said he hopes that I'm living in fear because he's going to find me. I wear a mask from that point on in public everywhere because I know the people that he attracts to this page and the people that he deals with on a daily basis aren't very like upstanding citizens, I guess. They're more apt to act on ignorance rather than fact. So it was dangerous what he was doing to me. I got cameras all over my van. I park only in front of like businesses with cameras in there because I know he's actively trying to find me. I've had people, while he was posting stuff about me, ask if I was the guy on Facebook or if I was John Connolly. And, like, these people are trying to find me.
So did you end up applying for a protective order?
Yes, I did.
And did you get one?
Yes, I got a temporary restraining order.
Do you recall the date of when you got the temporary restraining order?
I do not.
I know I asked the court to take judicial notice, but
Of our own files, yes, you did.
yes, so it was issued on October 22nd of 2021.
Thank you.
So you said you got a temporary protective order. What type of contact did it prohibit?
All type of contact, either like, first person contact or through third party. The main thing I was trying to stop is the slanderous stuff he was posting on Facebook and just the type of portrayal he was doing of me to the public. So I had, he portrayed me as a monster. I understand what my charges are. I made a mistake. I'm trying to move forward as best as I can.
And did you have a final hearing on that protective order?
I did.
Okay, do you recall when that was?
He moved for a speedy trial, so I believe it was maybe 2 weeks after that.
So the end of October?
I believe so.
And did you appear at that hearing?
Yes, I did.
Did Mr. Parisi appear at that hearing?
Yes, he did.
And can you just very briefly describe what happened at that hearing?
The judge asked for evidence, and I said that, it was on a public Facebook page, that, I'm not allowed to go to. I can't use Facebook. So I asked him just to review all the videos. I had videos on my phone sent to me, and I had a lot of them, and they were like 3-minute rants, 6-minute rants, and I wanted to show the judge it in its entirety so he could understand the context of what he was saying. and the judge did not want to review the entire thing. He wanted me, to condense it.
But did you make it clear during that hearing that you, although you you're prohibited from having access to social media, but you still have access to people?
Yes, I showed him my phone, and he looked through it, and, he played a quick clip, and it just seems like he was in a hurry, and he asked what part exactly was the part pertaining to me. I wasn't exactly sure, because there's so much content. So he didn't look, he didn't really review it.
And did he make a decision about the continuance of that protective order at that hearing?
No, he took it into consideration.
Okay. After that hearing, were you made aware of any additional posts that were put onto Facebook?
Yes.
And when were you made aware of that?
It was, sporadically. I go to usually 100 Nights parking lot, like every day, and they all are always telling me stuff, about posts. I know that when he's violated the restraining order, he was there very late at night. I guess someone...
So I'm just going to stop you for a second and go back a little bit.
Yeah.
So there was a particular post that came after that, that hearing. Do you recall what that was?
I'm not sure exactly the time frame, but I know that he was outside 100 Nights shelter, and he said that I am not where I'm supposed to be. He said you're supposed to be he didn't use the term absconding, I believe, but he said, you're supposed to be here, you're registered here, I'm looking for you. Basically, he was checking up on where I was supposed to be.
And you were made aware of that post?
Yeah.
Did you view it somehow?
Yeah. Yeah.
And what did you do when you saw that post?
I took it to the police because I thought it was a violation of the protective order. He was at a place that he knew I was at. He was looking for me, and he said by name on Facebook that he was looking for me, and so I took it to the police station and just said, hey, listen, this guy's still posting stuff. Yeah.
Just a second, I'm sorry, Mr. Connolly. May I approach, I just want to have him view this video again to confirm that's what he is.
You may. Mr. Parisi, you've seen a silly question, but you're
Yes,
familiar with what she's
but maybe-
doing. Why don't you come on up to where you can see as well?
It's the jail paper. We survived. Higher quality, we're going to stop doing live videos. Because apparently today, someone watching the live video called the police and said that I was stalking John Conley. One nice gentleman from the state troopers and one nice gentleman in car number 29 from Keene PD came to speak with me. And as you can see, no silver bracelets, and I'm not stalking him. But listen, John Conley, why don't you report to where you're supposed to report to? You're not supposed to be in a van down by the river. You're supposed to be in bed at 100 Nights, because that's where you're registered to, mister. I'll be watching you. Thomas Parisi for the jail paper.
Do you recognize that
Yeah.
video?
Yes,
Mr.
I do.
Connolly? Is that the video that you brought to the police department?
Yes, it is.
Ultimately, what happened to the protective order? What decision did the court make?
I believe it was dropped. No finding.
Okay. Do you recall when that happened? What date it was vacated?
I don't.
Was it before or after you viewed that video?
After.
Do you see Mr. Parisi in the room today?
Unfortunately.
Where is he?
Directly in front of me.
Okay, can you just briefly describe what he's wearing?
a red tie and gray Crocs.
Okay. I just would like the court to take the record to reflect that the witness has identified the defendant as Mr. Thomas Parisi.
It will, thank you.
I have no further questions.
Mr. Parisi, it's your opportunity to ask this gentleman any questions.
Your Honor, I've been looking forward to this.
No trouble.
So, how are you this afternoon, Mr. Conley?
I'm doing okay.
All right. So, Mr. Conley, are you a convicted felon?
Yes, I am.
Okay. And is it true that you were convicted of, what would be RSA 631, 2, I believe, felonious sexual assault, as well as a second-degree assault, and a felonious sexual assault, sexual contact with a victim under 13 on
Yeah.
July 23rd last year?
Yes.
Okay. All right, so is it true that part of your sentence of this conviction that you are required to register all your name, your likeness, your address with the New Hampshire Sex Offender Against Children Registry?
Of course.
Okay, excellent. Give me just 1 second. Bear with me 1 second.
No trouble at all.
So much papers, I made a real bad mess over here. If I can see if the witness recognizes this.
You may, would you show it to Attorney Rourke so she knows what you're doing? Thank you.
Mr. Conley, do you recognize this document?
Yes, I do.
What is it?
It's my registration.
And how is this accessible?
Online.
Online, okay. And, in your petition, you state, let me briefly go back, sorry. So you are required to update your address at any time that you move from one place to another, is that correct?
Yes.
And you're also required to report that to probation as well, but just besides the registrar, the probation is the one that handles it, or who handles your updating address?
I have to check in with my probation officer with anything I do, anywhere I sleep, every day. And also Donald Lundeen, Detective Donald Lundeen at the Keene Police Department, who I believe handles the registration information.
Okay, excellent. All right, now, let's see. So how long do you have in a certain circumstance? How long do you have from when you are going to go from one domicile to another to report to those said probation officers that you're moving? How long are you required by, or allowed by
I'm
law?
going to object. I'm not sure how this would be related to a violation of a protective order, whether or not, how he's reporting, or whether he's reporting, or what he's reporting, or when.
Your Honor.
Mr. Parisi, tell me the relevance
Certainly.
to the charge.
I'm in investigative journalism. All of this is within my First Amendment rights of doing an investigative report about an absconding sex offender who fails to report to where he's going. The crux of the matter is that I was in the midst of my freedom of speech at a protest against 100 Nights and this individual, and now it's been twisted into something else. So the relevance is, I'm trying to establish that he's aware, as he put in his petition, that I'm a news reporter, which is what he mentions in it. That's what I'm leading up to.
The complaint is that he posted a video of himself outside of 100 Nights making contact with Mr. Conley.
Sure, and I can shorten this up even more. I think the gentleman's already acknowledged where
Sure,
you're from.
then we'll move
So I
on.
think we can move on. I think the issues already have been addressed.
Yeah, I'll go a different way around the barn, Your Honor. I
Thank you.
appreciate it. So then, when did you become aware of the Facebook page known as the Jail Paper? The exact date, more or less, if you could.
The exact date, I don't know.
I believe it was Attorney O'Rourke had messaged it, but I believe, if I can hand this back, could you read the dates on your said text messages so that we can acknowledge at least more or less? Can you see what the date is?
Yes, my said text message is 9/24/21 at 12:50 a.m.
Okay, excellent. Now, approximately when did you lose the housing at 100 Nights that you had mentioned before? When was the housing debacle had come across?
I don't know, I didn't write it down in my diary, no.
Okay. Would you say that you had been at 100 Nights on or around when you had filed the actual petition? Or when in this alleged loss of housing, when was it that you actually lost housing at 100 Nights? I'm trying to establish this, Your Honor, because I have documents for this. When did you lose it? What
I
date?
don't remember the date that they threw me out and asked to stop having contact with me. I'm not sure.
I have here, Your Honor, a printout that I believe I do have 2 copies. It's the registry that I entered into evidence with Judge Donovan, so it is already entered into evidence, but it's the roster of individuals that are staying in 100 Nights. One of the individuals is actually in the gallery, but the names of every individual that stays at this homeless shelter is on there. Mr. Conley Jr., before he was actually kicked out, his name is not on there. So I'm trying to establish that the reason for my investigative journalism that led to this alleged violation of the court order was because I was practicing my First Amendment constitutionally protected rights of freedom of speech, freedom of assembly, and as an investigative journalism. So that's kind of where I'm going with it.
How is disclosing the names of people staying at 100 Nights?
Well, no, what it is his name doesn't appear on the list
How is it helpful?
because he's lying about having been there. He
Well,
wasn't.
You can get there with that.
Yeah, he wasn't actually there. But
Well, you can cross-examine him on that,
Oh.
and if his name's not on the list, it's not on the list.
do you remember where you were on October 14th of 2021?
No.
Okay. If we could pass that along to him. So this is Your Honor. I have one more copy for both the court and Mr. O'Rourke. But this is a list that I'm presenting. If you could tell me what the list is, Mr. Conley, if you recognize.
Well, you don't have to,
Well, I've already said that.
yeah, you can
I'm-
ask him a question.
I'm
Don't
telling
show that to the witness yet, it's not being proffered. yet.
Okay, so we'll take this.
Do you want to ask him if he was there that night and
Were you there? Yes.
ask him why his name wasn't on the list, if you have a list where there's no name on it?
Do you know why you weren't there on October 14th? If at that time you were registered to there?
Like I said, my probation officer and Donald Lundeen knows where I am before I'm there, every night.
Oh, perfect. Your Honor, I've got it now, so I'll make it more concrete and wrap it up. So basically, on this thing that you've already seen, your address is 17 Lamson Street. When did you change your address from 17 Lamson Street to homeless, which it currently is on? When did you change that?
I could get in touch with Donald Lundeen.
Do you remember more or less when it was?
No, I don't.
Okay. Your Honor, I don't have a timestamp on it, but it was far after the actual incident. It was far after.
Well, you're testifying now, so
Oh, sorry.
you can wait until it's your turn to testify.
Yeah, sorry. So I'll wait till then.
No trouble.
I'm going to wrap it up right now.
No hurry at all, take your time.
Oh, okay. So now I would like to see on this petition, if you can read on the final order of the petition, if you could just read what Judge Donovan said in regards to this alleged stalking. If you can just read this, do you recognize this
thank
document?
Thank you. Okay, it says the plaintiffs has not been stalked, as defined in RSA 633-3A, case dismissed. Says that the plaintiff, he has had no contact with the defendant since late September 2021. Plaintiff alleges only that defendant's conduct has resulted in losing housing. I have no idea what.
It's a reputation, I think. That there's a,
Sure, I'll go with
but if
that.
you can read whatever, the last little part right after that, there's like 5 more words at the end of that sentence.
Something about personal safety.
I believe it reads with Judge Donovan's
You'll
rights.
get a chance to testify. Right now is your chance to ask him.
Sorry about it, Your Honor.
No, you're doing great.
It's not as easy as it is on TV, so they have a script to work with. All right. You know what? I think we'll wrap it up there. Thank you, Mr.
Attorney
Chairman.
Work, anything to polish up? This gentleman step down? You may, thank you, sir.
Thank
may
you.
step down.
State restaurant.
State rest, Mr. Parisi, state is rested.
Yes, yeah. Well, Your Honor, I don't have, I mean, I can testify. So if I could do that, Your Honor, it doesn't make sense to me as a pro se litigant. I'm still kind of not great at criminal procedures because I'm just a college student. If I testify, how do I would just testify in the minutes or work would cross-examine me. Would that be correct?
That's usually how it works.
And then after that, do we do?
And you're under no obligation to testify. It's the state's obligation to prove your guilt. It's not your obligation to prove your guilt.
I'm still going to protect my, you know, obviously my constitutional rights, but I would like to testify on my own.
Come on up.
All right, let me just bring up my little thing.
Do you affirm the information you're about to give will be the truth, the whole truth, and nothing but the truth under the pains and penalty of perjury?
Yes, sir.
Please be seated.
Thank you, Your Honor.
And even though we all know who you are, please state your name for the record.
Thomas Parisi.
Mr. Parisi, what does he like me to know?
Well, what it is now I had made a video, which we have all seen about 2 times. The video is of old content, which happened to go up on the jail paper on, I believe, the morning of October 31st. Now, what I have a mail to express to the court is during the latter part of September, most particularly when John Conley Jr. had messaged me on September 26th, I had began a television series, an episodic, how should one say it? A series of episodes of sex offenders here in the local Cheshire County area that posed a danger to young children soliciting candy door to door in the Cheshire County Keene area. So what I had done is, besides Mr. Conley, I had done a series of videos on numerous other people. During this little, I guess this video of the October 31st, which was posted at 3 a.m., there was an encounter I had on October 19th at approximately 1 a.m. What I was doing at 1 a.m. on October 19th of that video is I had a protest, which I had set with the city. I had a protest in front of 100 Knights, not just because of Mr. John Conley Jr., but for the 4 other sex offenders that were there, and Jeff Nass Jr., who is the son of the shelter manager, who's also a sex offender, was sleeping outside in 35-degree weather. So I was in the midst of practicing not only my freedom of speech, not only my freedom of the press with the jail paper, my salacious magazine, but it was also my freedom of assembly because I was there with 4 or 5 other people with the same cause. So, I mean, we should say that the crux of the matter with this is, yes, I did post that video. However, Your Honor, I have posted that video again. The second time I posted that video might have been, I don't know if Attorney O'Rourke has seen it, but I posted that video maybe 2 or 3 weeks ago. However, in that same said video, I censored out his name. In a video that the prosecutor did not put in this, which is my college homework assignment that led to this, is a series that I had done. Could the bailiff grab that big, large sheet of paper?
No, you can grab it.
Oh, I can grab it. Thank you, sir. It's called 100 Nights of Terror. And it was a 30-minute documentary, as well as my printed newspaper, which I've been doing for 10 years, because I printed this out.
Has Attorney O'Rourke seen this?
Oh, sorry.
Can I just show it to her?
Certainly. And I have regular paper copies of it, so. And so what this was is I had, you know, in conjunction with not just doing the television show and publishing all this, I published an entire amount of material about John Conley Jr. On October 29th in front of Judge Donovan. I had said that I'm going to continue to publish, you know, information, but I was not going to do it in a manner of violation, but I was going to continue on with publishing the trial, which I had every right to publish a trial, but in no way, shape, or form, I'm a journalist. It's like implode, explode. This is where I come from as a
as a college student, as someone who's trying to bring the news and disseminate information for not only public safety, but for the public good, at no time was this man threatened. In the video it says, stop living in a van down my river, because he's not reporting to where he is supposed to be reporting, and his crime was against a child who's under 13. So as an uncle, as a concerned individual for people that have children in the community, I felt compelled to continue, and I'm still continuing to publish it. And like I said, I published this video again in 100 Nights of Terror, and I bleeped out the John Conley's name with a horn, but all I do is I refer to him as John Doe. But all that this individual has done, all that Keene Police have done, in my point of view, is they're persecuting me and using the courts to stop me from publishing information that the public has a right to know. I find these criminals, most particularly sexual predators preying on our children, to be the most dangerous of the criminal element. I get along better with people on aggravated manslaughter charges. So in saying that, I felt compelled to be my duty. And today, if I have to go to jail for it or receive some type of penalty or crime, I don't believe that I should, but I believe it was necessary at that time to let parents, single mothers, know that their children should be very cautious with this said individual, John Conley Jr., running around Walmart and running around the Target parking lot and hanging out wherever he wants to, because he's under the scrutiny of the state for a reason. Because offenders like him create anxiety in my heart that another child's going to fall victim to it. So that's why I made these series of videos. All of these videos were under my constantly protected First Amendment freedom of speech. In no way was it geared towards terrorizing him, violating the court order, or in some way intimidating him. Unlike State versus Craig, which I'm presuming the court's familiar with, State versus Craig, the guy is raving like a lunatic and harassing this poor woman. In my case, I'm simply looking for him. Now, there was never any contact made. On that same said night of October 19th, the video which Attorney O'Rourke had showed, the state troopers had come, and I believe it was car 29 from Keene Police, and I have a video where they're actually like driving up, which Attorney O'Rourke didn't bring in, but even then, I was looking to knock on his window while he's sleeping and ask him, why are you not at your place? You're a registered sex offender, in an investigative reporter capacity. I'm not going there, like I'm a street person in a certain regard. I'm a delinquent in a certain regard, but I'm not, this has nothing to do with me wanting to beat him up or all this delusional stuff that he said that I'm being mean to the homeless community. I've had 12 to 13 people that are homeless live in my house since November. So I find that most of what Mr. Conley says is just completely untrue. My blame that I know is I should never have put up a video until after something had gone up. It was one of those things where I put up a barrage of videos, because I was Halloween, I was putting up a whole bunch. It was my season finale, and one of them I didn't edit. So the worst thing that I could have done is just poorly edit, because I'd publish it again. I'm surprised you didn't see it, but I'm going to continue so long as my freedom is not constrained. I'm going to continue to bring news that registered sex offenders like John Doe, aka John Conley Jr., James Doe, Thomas Allen Jr., who also felonious sexual assault, victim under 15. I'm going to continue to do that. So in wrapping up on my part, because I already aced myself in the gutter, but I believe that what I did was not a crime. I believe what I did is I misstepped, and I published a video that I should have a little bit more sense to have censored out his name. But that's the worst I did. But what I was doing was during a time of First Amendment, constitutionally protected. And that's it.
Any questions?
Mr. Parisi, do you recall being served by Keene Police Department a copy of the protective order that was issued on?
Yes.
So you recall being served that? Do you recall getting a copy of it?
Yes.
Did you read it?
And yes, and it was actually at about 6:30 in the morning on Sunday, October. It was 2 days after, so I want to say October 24th. Then I forgot what officer it was, but it wasn't Jermaine. But it was a nice man, but we talked for about 15 minutes, and he just ran through the whole call. It might have been Copo. I think it was Officer Copo. Good, see, I like Copo.
So you did Did
No.
Officer Bobo explain to you? what-
In great detail as required by law.
So you knew you were not supposed to have contact with Mr. Connell?
Mm-hmm.
You yourself not having contact with Mr. Connell?
Yeah.
I believe you already introduced this.
Oh, of course, yes.
So I don't need to review the whole thing again, but I would like you to identify for the record what date that
November
order
5th.
was.
Friday, November 5th.
Okay.
Just before 4 o'clock. Just so, if I can add on to that, I'll acknowledge that I know when it was because I had called up the courthouse, and to specifically make sure that I covered my bases, that the clerk remembered I had called and asked her if it was dismissed, is I told her, have I told you today how much I love you? So that way, when I called back a week later, it's stuck in their brain. So yes, I'm very well aware of when it was dismissed, so like 3:50 on Friday that afternoon.
What was the actual date? There was a little talk.
November 5th.
November 5th. All right, Your Honor, I have no further questions.
Thank you. You may step down, sir. Case submitted, Mr. Parisi?
Do we have closing arguments, or?
You may.
Oh, do I go first, or she? Oh.
Attorney Work, do you have anything else? You could have some rebuttal. It seems like a silly question
I do not
sometimes. Do you have
have
anything else?
I do not have any rebuttal, Your Honor. I'm prepared to make an
I'll
argument.
bet you have a couple comments. All right, we may proceed with closing arguments. Thank you.
Okay, thank you. So this case is about, it really comes down to the State v. Craig and whether or not that video that we entered into evidence is considered a contact and communication directed at Mr. Connolly while an active protective order is in place. As you can see, and also whether or not Mr. Parisi had the intention of meeting that message to get to Mr. Connolly. Just to recap, the temporary order was issued on October 22nd of 2021 and served upon Mr. Parisi on October 24th of 2021. There was a final hearing on October 29th of 2021, in which case Justice Donovan had taken the matter under advisement and then ultimately issued an order vacating that on November 5th of 2021. The Facebook post in question was posted onto the jail paper on October 30th, 2021, a day after the final hearing and prior to the order actually being vacated. So the question is really, is that post, was it meant for Mr. Connolly, and should Mr. Parisi have understood that he would likely get that message? In State v. Craig, Mr. Parisi is correct. The issue there is this was two individuals, both private individuals, and neither one of them were related to or arguing about being part of being a journalist. He was posting these messages on a public Facebook page. The idea and holding in the court was that in order for a post on a public Facebook page that could be after receiving a restraining order, the victim in that matter had gotten a stalking or protective order, but that was a domestic violence protective order prohibiting the contact, and after that he was posting these messages on his public Facebook page. He had a public page, you could just go on, look, and she did that. She was avoiding doing that, but because of the nature of the messages that he was posting, she was encouraged by her mother to look at them, and so she actively sought out those messages to see what he was posting. The court, in that case, found that the state must prove that by posting his own public Facebook page after receiving a restraining order, that he engaged in a single act of conduct that constitutes an act of communication under RSC 644-4 and contact under 173B that violated the restraining order. They define communication, when they determine a communication, they're looking at what and how it was written or suggested in the posts that were directed to the victim in a public forum. So in this case, it's a public forum, the jail page is public, you can just look it up, you don't have to have anything special. And the state would submit that although Mr. Connolly is legally prohibited from being on social media, he can't have his own social media accounts, he can't be going around in there at all, he can have access to that in the fact that all of these people that are familiar with Mr. Parisi, that are familiar with the jail paper, can show that to him. And pretty obvious that that's exactly what happened. He had the videos, he had them at a protective order hearing. He reached out to Mr. Parisi in Messenger, identifying that he had seen these things. He had copies of those messages to show to the police department when he reported a violation. And so Mr. Parisi should have known all of that prior to posting that message on October 30th. He had the message from Mr. Connolly. There was a temporary protective order hearing that happened in which they discussed the access that Mr. Connolly had to all of that and how he was getting that information. And yet he still posted that video. What's unique about that video is that the state understands that Mr. Parisi acts in a capacity of a journalist and that he has every right and has First Amendment rights and he can expose all of these things that he wants to. All the information he's gotten has been primarily from public places. Where that became a violation in that video is when he directly looked at the camera and said, "John Connolly, listen, you should be at 100 Nights Shelter, not in a van down by the river." Had he not directed that message at Mr. Connolly while knowing that he is likely to have access and see that message, knowing that there's a protective order in place, that's when it became a violation of a protective order in the opinion of the state, and therefore he should be held accountable for that.
Thank you. Mr. Parisi, would it be helpful, some people like it, some people don't. When I was trying cases, I always enjoyed knowing what the judge was thinking, but, so I don't want to distract you from.
Any wisdom for the court is welcome.
I assure you there's no wisdom, but I can let you know what I'm thinking.
Okay.
And that sometimes, I found it to be, when I've been in your position, very advantageous, because it's often difficult to read a judge's mind. But, so, if you could, among other things you want to address for me right now,
Yes.
the state ended with the primary concern I have.
Yes.
And let me preface my comments with don't let me dissuade you from whatever it is you hope to do now. But it is hard for me, sitting as a judge, to watch the video twice and hear you say what Attorney Rourke just indicated you said, and then end with, "I've been watching you." And that happened, if I understand the chronology from my court record.
Yes.
That happened the day after the final hearing.
That video was published on the 31st, and the hearing in front of Judge Donovan was the 29th.
Yeah.
But the original content, and I could show you off my phone, the original content was October
So
19th.
you publish it after
In a barrage.
the final
of
hearing.
things. Yes.
Well, the barrage doesn't.
Yeah, but no, I had published it after that.
No, and again, that's why I'm just letting you know areas where my eyebrows are raised. Like,
Naturally. Like I said,
I'll bet you're pretty good at this, and I'll bet that wasn't a slip of the pen, as
No.
my concern.
Yeah.
So, if you want, and you don't have to address that. I'm saying the second time, and I mean it. You're a savvy gentleman, and you know it's not your obligation to prove your innocence. It's their obligation to prove it. But that's one hang-up I have. Because you said you wanted to talk to me, you wanted to do a close, so I'm giving you some insight on what I'm looking at. And so it's difficult for me to conclude anything other than that wasn't.
Well, I have a good one for you. Now,
Go.
here's what we hit into where John Connolly, the liar, makes it so. What I had posted there, he had said, now I wish I had 100 Nights of Terror, but you could go.
You wish you had time to what?
I wish I had 100 Nights of Terror to show you.
Oh.
But you can imagine that you're, a judicial officer, the same as yourself, Judge Donovan was here. So now he had told Judge Donovan that probation or London or whoever it was had erased and deleted his Facebook. He said that in court. He said he had deleted Messenger, he deleted his Facebook. Now, my phone's dead. I don't need to prove he still has Facebook because I know he does. But he had said at court that he had deleted his Facebook. So presumably on my end, since he had not, now he is a convicted sex offender using Facebook illegally, telling his probation officer that he's not using Facebook, doing it legally.
Can I stop you there? Was that part of the record? Were you even in on that first one? Were you even in when Justice Donovan was here?
I was not here when that would have been a protective order. I had reviewed the footage. I had reviewed the audio. he has stated, and I believe Mr. Connolly did state here on the record, that he didn't understand that Messenger was actually Facebook.
He did say
And
that
that
today.
he notified his PO, and that
Sure.
they deleted it from his phone. So it would just be
Your
Messenger,
point-
not
your point's
Facebook.
well taken.
Yeah.
on that. I just, and again, I wasn't doubting what you said. I just wanted to make sure we're all on the same page.
Yeah, no, and I can understand, like, the court, obviously, I've already aced myself in the gun to a certain extent, but I want to explain my actions. When I presume that, okay, he's now said in front of a judge and in front of, in court, we're under penalty of perjury, he's not going to be on Facebook, then he shouldn't be on Facebook to begin with. Now he's sneaking back on Facebook after he took it off his phone, because when he says that this violation took place, according to, Jermaine's not here for us to go through his narrative, but if we look through Jermaine's narrative, he contacted Jermaine either like the morning of Halloween or the night before. That was a day and a half after he was standing in this courtroom with Judge Donovan. Now, what he says in his narrative is that a friend had come up to show him. But so now a friend had told you, but your friend had seen it on the jail paper, which is the television show that everybody knows. So it wasn't directly to him because he wasn't supposed to be on Facebook. And Facebook is not publicly accessible. I guarantee you, if you type in the website right now on that computer, thejailpaperkeen.com, if you do not have a Facebook, you cannot see it. It was not on YouTube. I never published that video, and the prosecution only admitted that that video is on Facebook. The Jail Paper Keen can only be accessed with a Facebook account. So under my understanding, when I did publish that, and whether, it's totally on me that I published it, whether I barrage, whatever nonsense, but at that moment, which was some, like 36 hours after having been in front of Judge Donovan, I was under the presumption that this person who should be in prison would not be on Facebook. The lunacy, what gets me, and I'd like to interject this into my closing arguments, is that the state's prosecution of this now dismissed ex parte against me in favor of John Conley Jr. is.
Well, I can help you with that.
Okay.
That's not what they're prosecuting you for.
Okay, yeah.
It's
for actually-
prosecuting you for violating a protective order. That was
by putting that video up after.
Right, and you said what you said. I mean, I've heard it twice.
Yeah, I
I've seen
mean,
it twice, and you end with, quote, "I have been watching you." I mean, you make it pretty plain.
Oh, I'll be
You're not
watching.
You're not directing at me.
no.
Okay.
But you have to have Facebook.
I just wanted you to know
Oh, no, I know.
what you're being prosecuted for today. You're not being prosecuted because of John Connolly. You're being
No.
prosecuted for violating a protective order.
But the best thing one can look at is when you look at it, YouTube is something that's publicly accessible. Like if we're going to go on any computer,
Let's not talk about YouTube.
Oh, no, yeah, so it's not on YouTube, it's only on Facebook. But Facebook can only be accessed for that, so let's wrap that up.
You've mentioned that a handful of
Now I'm
times.
going to wrap that up.
I heard you the first bit.
I appreciate your patience, Your Honor. I don't do this for a living, so. The speech allegedly that I put in that video, I understand that it can be construed that that's directed at John Conley, but it's not taken out of context. One should say that if you see the video again with the censored, I wish we could show it. I don't have battery in my phone, but you could see the same video. I put music to the background. It's no more threatening than it was. Instead of me saying John Conley Jr., it just beeps a horn. I mean, if I would have done that, then we wouldn't even be standing here. But I believe I was in the process of making a First Amendment constantly protected right. I was not addressing John Conley Jr. directly through Facebook. I was posting a video that I happened to have in an encounter in law enforcement during a protest against 100 Nights, a place where John Conley Jr. was not reporting. From the beginning, John Conley Jr. has been lying to this court. I'm being persecuted for trying to tell the truth. John Conley Jr. is going to win for it. So to wrap it up, Your Honor.
You're not being persecuted for telling the truth. I have a complaint in front of me. You
Oh, no, I know.
have it.
And it's
You're
not the
being- You're
court.
being prosecuted for violating a court order.
Yes.
Nobody's infringing on your First Amendment rights here that I could tell. What I see is, what I see is an allegation that you violated a court order. You're telling me it was unintentional, and you've given me reasons for it being unintentional.
But I'll ramp it up, and I don't want to seem like I'm taking a shot at the court. I didn't want to say like persecution. I should have rephrased.
Oh, I didn't take it personally. No, I just wanted to. I wanted to make
I
sure
respect this
you
court.
understood what it is. I'm focused on. I'm not focused on you being persecuted.
Yeah.
I'm not focused on your.
But
I'm
what
focused on the complaint.
Well, what I should say is from the beginning, this restraining order should never have come into fruition. Like, if I can briefly just lay out why, is that I had never...
No.
Oh, no.
You can't, that's gone. I
Okay, that's
understand
fine. Yeah,
it's
we already
been
know about
dismissed by Justice Donovan.
Exactly.
We're here today on you
Yes.
violating a court order that was in effect at the time.
Yes. So the good thing is, it was dismissed. It really should have never come into fruition because I was only from the beginning practicing my First Amendment rights.
You've mentioned that a few times. Do you have anything new for me?
Now, last thing is that
Is it new?
Implode Explode. You probably know Implode Explode.
Go.
Okay. I'm trying to say it so I'm not repetitive. I believe I will rest.
Thank you.
You're welcome.
Case submitted. I think, I appreciate the candor of both sides, and the case was well tried, and I think that it's not just the litigants that owe candor towards the tribunal. I think the tribunal on occasion owes the litigants a little candor, and I just for the life of me can't recall, and I'll bring it up, but I just can't recall the case, so I'm going to go back and look it up right now in Westlaw, I'll print it off, and I'll read it and see whose interpretation I find to fit my analysis of the case. So I'll go do that right now, and I'll work very hard to get an order out today. I may not be able to get an order out today, depending on what we have for emergencies and the like, so I'll try very hard to get it out today, but no promises on that. But I will go read that case right now to refresh my recollection on it.
I know, Your Honor, one quick question. So far as this is a criminal case.
It is.
How does this, I mean, there can be criminal penalties, but what should I be doing now? 'Cause
You don't strike me as the sort of person that I need to issue a bail order on now while your case is pending. So,
Okay.
The conditions of bail are the conditions of bail, and this case is still alive until I reach a decision. So
Okay.
that's where you are.
Excellent, well, thank you, Your Honor.
Thank you. Case submitted. Court's adjourned. Thank you.
Please
both.
rise.
All right, so out here in front of the Cheshire Courthouse with Thomas Parisi. Thomas, any thoughts on how things went in there?
It was an interesting time. Basically, if my long and the short of it, I am a guilty journalist for caring too much about bringing news to people. That's basically it. I had a trial of a now dismissed restraining order against a sex offender who I've republished this video, as I said, in front of the court numerous times. I haven't caught another violation, but it's unfortunate that we live in a community that protects those that do damage to our most vulnerable people.
When you were on the stand, do you think you went a little too far?
Oh yeah. Oh yeah. But I'm a delinquent. I'm a street person, allegedly by the word of John Conley Jr. So, yeah, I hang out with homeless people that live at my house. I bully bad guys. I'm just basically a mean guy to mean people, but it's okay. And I basically told the judge, I'm a street person, I'm a delinquent, but that's not what I'm on trial for. I'm basically on trial for being an idiot and publishing a video from a week before at the wrong day. So you know what? I'm fucking guilty. Who cares?
Now, I mean, that said, maybe they will find you guilty in this case.
Yeah.
But it seemed to me that you could have argued that it was simply art. That not only was it journalism, but it was sort of performative art. In that,
if
in
it's
that
okay.
yeah.
You know, Thomas Parisi, here in the jail paper, usually what I do is I speak like this. Now I say, yes, John Conley Jr. is hiding in a van down by the river. Now, what bothered me is that nobody yet has gotten this, not an anecdote, but the joke, living in a van down by the river.
I get that. I get the reference. It's a reference to, was it Chris Farley?
Lord, this came in. Oh, I have gas money for you.
That's okay, I'll be right down here.
Oh, I'll be right over.
No, take your time, I'm gonna have a cigarette.
All right, my dear.
It's a reference to now deceased comedian Chris Farley.
Chris Farley, yes.
I believe Saturday Night Live, where he played a homeless guy lived down by the river. And in this case, you were obviously referencing that because this guy didn't live by the river per se. It was
Yeah.
just clearly a
It was
joke.
it was a reference, and what it is that this individual, John Conley Jr., he's a registered sex offender. His original charge was facing life in prison for aggravated felonious sexual assault against a victim under 13. What happened is he pled out to a felonious sexual assault, second-degree assault, and a misdemeanor sexual contact victim under 13. But what my main premise is that I had gone around after he had contacted me, and I had done this a series of episodes of 100 Nights of Terror, which is a homeless shelter that had a large number of sex offenders where he was living. He was not registering or going to where he was supposed to. So ultimately, just in bad taste that I published a video, but I'll say it again and again, as I said in Judge Donovan's thing, this guy's a child rapist, and I'm going to be smarter and just use John Doe until this new restraining order in this case is gone. Because if you say the wrong thing, you will be prosecuted by mean prosecutors. They'll figure out a way.
Yeah, I mean, to me, it seems like you're well within. I thought the argument that was interesting was that he shouldn't have been on Facebook.
No.
You posted this video exclusively to Facebook, knowing in theory that he shouldn't be able to see it.
Yeah.
But even, to me, the content of the video was still artistic in that and I haven't read the whatever the restraining order said, but normally when I consider contact to be is you send him a message directly.
Yeah.
You know, posting an opinion about how this guy should be, where he says he's going to be, is not a direct contact in any way, shape, or form. You didn't tag him.
Nope.
You didn't send it in an email to him.
And it was on Facebook, which I explained to the judge, is that Facebook, if you type in thejailpaperkeen.com, it takes you, if you're not logged into Facebook, it takes you to Facebook, but it says you got to log in.
I checked it. That's true.
You know what I'm saying? So like it's, like I'm a person, I have to use Facebook, but like you don't. But you know, like, and I'm trying to get away from Facebook because it only causes problems. But if you're not allowed on Facebook to begin with, if you told your probation officer that you erased it, and then I'll prove it on the jail paper tonight, he's still on Facebook. So this is a guy who's lying to the judges. This is a guy who's a felon, so you can't believe anything he says, and it's a child rapist. It's one of those extreme cases, but I'm very grateful for the support of people like you, Ian, and my friends that showed up, my support team from the little jail paper. But it's one of those ultimate things that we live in a state that really upholds the First Amendment right. There's a very simple case called a mortgage specialist versus implode explode. It was a little group that was going after, like people who have, what was it, inflatable mortgages? You know what I'm talking about? Like, they scam mortgages back in 2009.
Right.
Basically, this mortgage person got a restraining order on him, said they couldn't publish anything. Supreme Court of New Hampshire overturned that and says that every sort of publication is the press, is the news. And I have the same rights as Chris Hansen would. But unfortunately, this prosecution's been smart in this case, is that originally they were going after me just because now they're like, oh, well, you are a journalist, but what you did was wrong. But long and the short, I'm from Florida. I'm a Miami person. My friend, Mr. Freeman, he's also from Florida. And if I was in Florida, dude, I could say I'm going to rock him right now, and they couldn't do shit. I could say, John Conley Jr., I'm coming to kick your ass. They couldn't do shit. I wouldn't say that. But unfortunately, we live in a state where some of the laws on sex offenders need to be more stringent. If I have to do a little time in jail, I'll do it. I'll pay a fine. But guess what? When I come out, I'm going right back to it. So,
Yeah, I wouldn't pay the fine if I were you. Just encourages them.
dude, I don't have the money. I'd rather buy weed. I'll tell them that too. Like, bro, you tap into my weed form. But I want to thank both Mr. Freeman and everybody out there. And if you come across our thing, we're just the crazy jail paper time. Thomas Parisi, rocking the party, and thank you for tuning in for the Free King. Pleasure to see you as always.
Thank you. State ready for sentencing?
Yes, sir.
Mr. Parisi, ready for sentencing?
Yes.
Thank you. You may proceed.
The state is just asking that the sentence be 90 days in the House of Corrections suspended, 2 years good behavior, and no contact with Mr. Connolly. That's the extent of the sentence. We're not seeking any stand committed time.
Suspended for 2 years, you said?
Yes, Your Honor.
What's your response to the state's proposal, Mr. Parisi?
I'm looking forward to this. It's a pleasure to address this court. I think it's absurd. This is, as we know, an utterance of words against a child rapist whose victim is still on or around the age of 13. A man whose victim did not testify at trial because she was a child and would have been too traumatic for her to go through. My mission with the jail paper came, as you've seen my Salacious magazine, and in a court case, his original petition was dismissed by, I didn't realize at the time of dismissal, it was Justice Donovan of the New Hampshire Supreme Court, who found there was no merits in his original petition. The problem I made is I disrespected not only this court, but the court of Judge Donovan and the court of Judge Forrest by putting a video up that shouldn't have been up. I don't think I should have any time in jail because there was no crime. The assertion by opposing counsel is absurd. I'd like to see them do 30 days in house corrections to see how they feel, because they should have put this man in jail for not having reported to 100 nights like he should have. Probation also didn't do anything to it. This town is notorious, Your Honor, notorious for allowing these criminals, presumably particularly sex offenders, to get away with murder. So in my regard, I would ask that I be given the maximum penalty for a fine and be able to enjoy my life with my new fiancée and her daughter and her children, as opposed to have to be a prisoner from another man's crimes to a child's life that he destroyed. He destroyed the innocence of a child. He's not a victim. This assertion that Craig versus said, I'm sure that you've read right through my whole motion to dismiss. I'm willing, as with anything, I'm very happy to take this type of charge, because it doesn't hurt my feelings. You know, I'm going to appeal it naturally. I'm going to appeal it to the New Hampshire Supreme Court, but I would ask the court to give me the maximum fine. I don't believe any jail time necessary. I did 2 days. I learned my lesson. I learned it well. As I think I told you, I told this to Judge Forrest, Judge Donovan, Judge Rolls. The voice of the judge is the voice of God. Listen to it. I actually even said it in that. The mistake I made is that I was being stupid on social media, which now I'm no longer on social media. So my backing up is, I think the assertion of 90 days suspended sentence is absurd. 2 years good conduct is absurd. It's probation, all this other is absurd. I think that I should get a fine and go and sin no more. I believe that my journalism, which it is, I believe you have read it, which is a mortgage specialist, which is implode explode. This falls within the criteria of every form, or every sort of publication is journalism. That's what it was. It was not threatening. And the last point is that he was on a platform, Facebook, which he is still on, Sean Conley Jr. And Facebook has prohibited sex offenders, convicted sex offenders, to be allowed to use that platform. So I would ask that the court allow me to have a maximum penalty fine of $1,200, which I can pay by December, because I have to pay for a wedding by September. And that way I'm not taking away from my children for alleged misconduct. Thank you.
Congratulations on the wedding, but I want to clear, I want to clear based on your comments that you're not being punished for anybody else's conduct. You were convicted of violating a protective order. So that's what I'm going to base my sentencing on. That's what I've given a lot of thought to. Attorney Rourke, what is this gentleman's record like, the 90 days?
Mr. Parisi does not have a criminal record. I will point out, though, to the court that since his conviction on this charge, there was another temporary protective order that was issued against him. I don't know the status of that. And I know he is stated he's no longer on social media, but there have been several complaints that have come in since his conviction to the police department that didn't rise to the level of criminal activity, but allegations of Mr. Parisi continuing to harass and identify certain members in the community as drug addicts or registered sex offenders. So his conduct has continued, even though it has not led to an arrest. His underlying conduct of walking around and harassing people and videoing it and putting on Facebook has continued since then. So that is the basis of the suspended sentence.
Your Honor, I have and is recognized by Justice Donovan in the Conley versus Thomas Parisi, where it literally says, I'm a news reporter that John Conley put himself. I am a news reporter. I am a vigilante as well, but I'm not just some derelict delinquent going around trying to start trouble. These people that identify in the community, like, I don't know if you're hearing later, but Jessica Babcock versus Alyssa Lucy, both baby mamas of Jason Deere, someone who your department let go with like 5 kilograms of heroin and 28 ounces of crack cocaine. These are the people I'm going after. I'm not just looking for these innocent people. Or how about the people, Raymond Lay, or two other guys that chased me with knives last week, which I'm sure you heard of and tried to assault me, because these people are a danger in our community. And the problem is that the Keene Police Department is not only lazy, but they're shiftless and they need to perform really bad. But I believe the problem is the temporary restraining order, if we can clarify, that was a comment of Judge Gleason. The temporary restraining order said, no, Your Honor, you dropped it to J.P. Phillips versus Thomas Parisi or Matthew Phillips. I forget which one. These are fake Navy SEALs and so many names for him. But Your Honor, I am conducting myself well. I am now moved to Winchester. I'm away from here. I am looking for other venues and avenues to do. I have a new show that I'm trying to do called Sex, Wine, and Politics as opposed to Sex, Drugs, and Vigilantes. So I'm changing my ways. And I don't need to be penalized for reporting about not only the crimes that they have committed, but the crimes that they're continuously committing against not only our community, our citizenry, and our children. I have a thing called the Safe Camp for All. And with this reporting, I have made at least 3 to 4 sex offenders leave this within actually city blocks of here, between Federal and Western. They have left the area because of how much my Salacious magazine has done damage to them. There should be reputation. These people have been found out. We shouldn't have secrets in our community like, oh, people that rape children should be told about it and often by people who know how to myself. They're not afraid of consequences. I realize I've done something that's wrong. The only thing I did wrong here is not listen to Justice Donovan when he left the bench and said, don't do anything until afterwards. Because this police department arrested me the day after Justice Donovan had dismissed it, which is absurd, ridiculous, and malicious by nature. Because you're jealous, because I'm actually doing something you guys are too cowards to do. And that's my thoughts on this.
Give me a moment. So the bottom line is you'd rather pay a fine than have suspended jail time.
I would behave so well.
Hang in there. Well, I heard you, I want you to know, I heard you loud and clear when you said a couple times you've learned your lesson. And what you're convicted of is not the activity that may or may not be going on now. What you're convicted of is violating the protective order on October 31 of 2021. So thank you for appreciating that. Thank you for telling me that you've learned your lesson and be more respectful of court orders going forward. Give me a moment here. Mr. Parisi, I understand the state's basis for asking for 90 days suspended. That's not the court's function, though. The court's function is to impose a sentence for this conviction. And I disagree a little bit with your $1,200 proposal as well. I'm going to fine you $1,000. $1,200, I'm going to fine you $1,000. I'm going to suspend $500 of that fine. I'm going to suspend half of penalty assessment. What that means in plain English is you don't have to pay half the fine and penalty assessment if you're good behavior for 2 years as defined by the statute. Now, you've indicated you've got a wedding coming up. Congratulations. And you may need payment arrangements on the $500. What are you proposing?
Well, what I can do is, I'm working 100 with traffic control. So what it is I can probably do by, if I can have 60 days, or let's say like October 1st, something like that, whatever the court would decide, at least a 30 to 60 day period, I can definitely have it all paid off or have a payment.
Why don't I say 60 days to pay? Is that good enough? Yeah. All right, those are the terms I'll impose. If you go to the window and sign the IOU for that, you'll be good to go.
Has anyone told you you're a great man today?
Say what?
You're a great man.
Did you tell my kids?
Yes.
Can
Thank you.
I just ask how long the suspended fine is for?
2 years.
Is there a no contact provision on that at all?
That is, I'm glad, I wrote it down when you proposed that, and I neglected to consider that. My apologies for that, thank you for asking that. You don't have any objection, you told me before you don't have any desire to
At the moment,
contact that
let's
person.
just leave it.
I'm gonna put in you told me at the prior hearing, you were done with that.
I do that,
And I made note to Attorney Rourke that helped me with the spelling on Conley, is it
It's Connolly.
Conolly, first name John?
Yes.
Conolly, just one L, as far as we know.
I believe it's 2 L's. It's 2
Two
L's.
N's, 2 L's it is, that's what I wrote out.
Thank you.
Thank you for that reminder, Attorney Rourke, I appreciate that. All right, send you adjourned, thank you.